Please. Yes, Mr. Rakesh Sharma is appearing. What is the matter about?
In Annexer 1, while rejecting my technical bid, the core feature of the entire EMD was there, along with disqualifying. Then I will challenge this.
The conflict of which one is yours?
There is conflict
NCC.
of interest between these items 1 and 2. This in Annexer 1, you will also find BGR mining and next
BGR mining, you are not.
I am not. Next one is NCC.
Yes.
So this third one is VPR. This VPR was
No, we are not concerned. You are not representing them. Then why BBR?
yes,
BGR. We are concerned with NCC.
NCC. NCC.
As per clause 2.2.1b.
B of R.
Where is that clause?
I have extracted it at page 29.
Page 29 is a judgment.
No, I have extracted that paragraph 3.
Where is the RFP?
No, I'm sorry. In judgment was extracted.
In the judgment,
Where is the RFP?
it has not been annexed.
So after this judgment was delivered in the qualifying week, the art was given. I have
Just 1 minute. Any bit of order. Yes.
But let me explain the development. After this order was passed, this disqualification was there.
This was in relation to your matter?
Yes.
Yes.
Then I have filed a writ petition before this honorable court challenging that. My writ petition was dismissed and then went to Supreme Court. Supreme Court has again remanded. After remanding, again the matter was considered by this honorable court, and this honorable court found the regarding conflict of interest, whether it was there or not, is not for the tendering authority to see, but in the process of tendering was not cannot be disputed. And again, this was of my petition holding that the cancellation of the tender will be valid. However, liberty was given to it because in the meantime, after remand from Supreme Court and before approaching this honorable court once again, there was I have sent a letter to them saying that to remove this disqualification, and for which they have issued an Annexer 2, by which they have said that so far as the MCL and the authorities are, their own authorities are concerned, this disqualification is not be there, you will not be blacklist. You will participate in all tenders. But the problem now arose is that after this, thereafter, some new tenders are being floated by different other companies and government agencies, wherein this disqualification clause is standing on the way. I am not able to participate in the other tenders. Therefore, I have approached them once again, saying that please remove this disqualification, and if at all you have sustained any loss because of this cancellation of the tender and other processes, I am willing to deposit that money also. But not to forfeit of the entire amount and also disqualification. Because if the disqualification stands, there will be difficulty in acceptance of tender by other agencies who are floating different global tenders. Therefore, your lordships wanted the council for taking instructions.
But the conflict of interest remains.
That means.
So,
But the
so this judgment, you challenge this judgment?
I have some judgment. What they got.
Simply, they conceded that they will not proceed for blacklisting. So that was a concession which they did. And on the basis of that concession, the court has said there is no question of any review of the blacklisting or something of that kind. They will not do it. But so far as a conflict of interest decision is concerned, it stands.
We are also not challenging that portion of the argument. And what we are now saying, because this disqualification is standing on the way.
Correct. So why? But this judgment is staring at your face.
This judgment.
It has been categorically at page 132. The court has absolutely say. 186, paragraph 186 is very clear, categorical.
186,
132, paragraph 186, page 132.
Yes.
Supreme Court is withdrawn. In Supreme Court, they are good for some time and withdrawn. Next question. This final, okay, against time.
So this top paragraph 186 is very clear.
No, it says that, however, in the peculiar facts and circumstances of the present case, and in view of the natural professional relationship between MCL on one hand and NCC and BGR on the other hand, we observe that we have not interfered with the decision to disqualify the petitioners on the ground of conflict of interest. And by
I'm concerned with this. What does it mean? It says that so far as the commercial relationship between the MCL on one hand and the NCC and BGR on the other hand,
yes,
we say that we are not persuaded to interfere with the decision disqualifying you on the ground of conflict of interest. But then they say, by way of a concession. That means the MCL conceded before the court,
yes,
has decided not to blacklist them.
Yes.
Now the MCL shall not review his decision on the question of blacklisting because they will not blacklist you on the ground of the subsequent conduct of challenging before this court despite the undertaking.
Next paragraph was last week.
Yes, MCL to reconsider the case for refund of EMD if forfeiture of the same have a consequence of their
disqualification
in any future tender process.
Participation in any future tender. This is what is kept open. Right? Therefore,
so they have to reconsider.
That's right. That's what is pending with them. My entire grievance is that I have made an application to them basing on this paragraph and also the Supreme Court judgment where the Supreme Court said that
Supreme Court did not say anything on that because against this judgment you went to the Supreme Court and you withdrew your SLP.
And matter was kept open to take other remedy.
No, it was not.
Page 153. Page 153.
Yes. After arguing the matter for some time, counsel for appearing for the petitioner does not intend to press this petition at this stage with liberty to avail other approach.
Sir, what is your experience over there?
But what I'm trying to support.
I can share.
Then immediately when I have given answer to the letter and the MCL has. But after all, the point is,
The only thing is, brother, no, this is only.
This Annexure 3 you are facing, that is prior to all
that was prior to that.
earlier writ petition.
Yes.
I think I was
Yes.
Your
lordship had heard that.
that was set aside by Honorable Supreme
Honorable
Court.
Supreme Court remanded.
Then
back.
remanded
Again, it was
again.
heard. Again, it was.
Huh?
119.
Yes.
Just one.
I will just try to impress your lordships with paragraph 183.
Now, after this judgment, have you not approached the
Yes, sir.
MCL?
I will approach. They have also.
Where is that document? Annexure 3 is not that. Annexure 3 is prior to all events.
Yes.
After this judgment in 2025.
Yes, but we have approached you. You also kindly see at page 137.
137.
We have given an undertaking for reconsideration of that, even to reimburse the expenses that were incurred. You hereby undertake to reimburse MCL with the actual legal and professional expenses incurred in WP.
No, that was prior to the judgment or after the judgment.
This was applicable. This is in only 26.
This is in 26.
15,
But there is no.
that was
15,
Yes, this is, no, I have seen. I was just trying to find out WP and SLP. Both.
this thing.
Why you not reconsidering?
Plus, it was found, they're reconsidering it because it's a PSU. Lordship,
No,
it's
So
Take
they
much
will
of
take
time.
1 year time.
not that.
PSU. So
No.
they have no limitations. They will just sit over it
They had.
For 2 years, 3 years, they will continue, we are in the process of considering. Then how the PSE will run if you cannot take a prompt decision?
This is on 15/1/2020.
Sir, we are in April, sir, 15, today is a 15. So
Mr. Sharma,
how many,
Mr. Sharma, the judgment is of 25, January 25. So will you not comply with reconsideration parties up to for you?
They approved in 2026.
Prior to that also, we have
You are appearing, no?
representation 27.
After that, there
Ah.
is Supreme Court. Thereafter.
In January 2025, the judgment is within your knowledge and notice.
I know. We have formed a committee was formed, committee had taken a decision, they had gone to this.
So now tell us how many days you will take? 1.5 years almost to come.
February, March, April, 3 months, today is 15.
You are
3
not
months
talking-
exactly has passed and you are running a PSU. If you cannot take a decision in a commercial matter, how you run a company? You have to take immediate prompt decision.
But in fact, I had to approach your lordships because today is the last date for applying in one tender. The lordship on the occasion wanted that.
That we can't, sir. You know your difficulty, still you are continuing to create these kind of things again and again and again. You are creating it. This is consciously that is within your knowledge. I have seen the observation in page 113, 119. The observations are against you.
And that is because of the subsequent development.
That is not a subsequent one, sir. You cannot create a cartel and then fuss the entire tender process.
Great respect, my lord, this honorable court, I did not enter into those things.
No, sir, this is very clear. When TCML, PCMPL, everything was there at 219. Your shareholding pattern has been disclosed.
But the conclusion was at page 128, you will also see.
It's not a conclusion. Conclusion is 119 if you come. Very interesting observation at page 172, paragraph 172.
What this honorable court ultimately found was that whether the calculation was there or not is not.
Sir, I am reading this sentence for you from paragraph 172. In our considered opinion,
Yes.
the said opinion formed by the tendering authority that the petitioners were disqualified because of the conflict of the interest cannot be said to be completely unfounded. That means the court has said, yes, there is a conflict of interest. If that is what is the observation, is standing or it's staring at you, because you were the rate petitioner, can you wriggle out from there? Third party I can understand, but it is your rate petition.
I can't wriggle out, nor.
And it is not the cartel with anybody, but cartel with BGR. Your cartel is with the BGR. And in this tender also, the BGR and you both participated. Both have been disqualified. So this is staring at your face, sir.
As on today,
Paragraph
as on
46.
today,
Paragraph
MCL itself
46.
has said.
Paragraph 40.
Thing is that as per this. No, we have to just fix a time because the timeline was not given.
Fix a timeline too.
Timeline was not given.
Just one minute, I will ask. Okay. So kindly see the paragraph 183 at page 128.
Correct, sir.
We accordingly conclude that no case of malafide has been specifically pleaded by either of the petitioners against an individual in the bidding process.
Correct.
It has directly been argued by the parties across the board that clause 221 pertains conflict of interest and clause 4G of so which postulates conflict of interest as one of the undesirable practice is to prevent cartelization. However,
Cartelization.
yes.
Yes.
However, in our considered view, for invoking clause 221 or applying clause 43D, cartelization is not required to be established by MCL. Rather, an existence of conditions for attracting the said clause is enough to conclude the conflict of interest.
Correct.
Therefore, further to invoke the conflict of interest clause, the concerned authority was not required to establish that parties alleged of having conflict of interest had in fact attempted to control the bid price.
That is what I was observing. This, the court has said that it may not amount to cartelization, not a cartel, but conflict of interest stands on a different footing, and cartelization cannot be considered to be a ground for that, but it has the tacit object to achieve.
Therefore, this honorable court ultimately.
So it's the cartelization stands on a different footing than a conflict. So far as a conflict is concerned, it is established that you have a conflict of interest. That's all.
Therefore,
Nothing more than that.
Ultimately found that in the tendering process, MCL has not committed any mistake in holding or disqualifying him. And now, therefore, I was drawing your lordship's attention to paragraph 187, where the thing was kept open only for this reason. And thereafter, also, as your lordships have observed, MCL has no difficulty. They have said that so far they are concerned, they are not blacklisting and they are allowing. Now the question is, because of this disqualification is pending, the other companies will not accept me. They themselves have no grievance, nor I have any grievance against them as on today. Yes. MCL is only to whether to refund the bid security or not. For that, I also conceded that whatever is your expenses, I am ready to reimburse. Because your lordship see the forfeiture as a condition as a damages. In Annexure 1, your lordship find the forfeiture will be as damages. I am ready to compensate them. Now, by lifting this disqualification, neither do they gain or lose. It is only with the other companies. So far they are concerned, they are willing.
You know, you have a same pace shareholding pattern. You know what is right, what is
We
wrong.
know that they are also bidding for this. That is difficult.
Having a substantive shareholding, you do not know that they are bidding.
No, I didn't.
Oh.
Online bidding was there. That is why this difficult.
That chapter is
Why should
closed.
you bid, man?
That chapter is closed.
That is closed. That is also the right thing said. It is one of the division bench judgments of Delhi High Court.
What is a shareholding pattern of the NCC and the BGR?
51 and 49.
51 and 49.
That is so
51 is NCC.
you are bidding as an individual company or you are bidding as a consortium.
Individual company.
So individual company is registered with the registrar of companies individually. What is the shareholding pattern? Where is your bylaws? Where is your article of association? Where is that? Show us. Who are the directors and what is the shareholding pattern? What is the capital, paid up capital? Show us. Who has contributed?
I'll make them available, my lord. And submission, my lord. Now, we are not challenging anything of the orders or
Because
we are not on that, my lord.
you cannot do it.
Only one submission. my lord.
Nothing submissions, no submissions is there.
One submission. my lord.
Everything you lost in the earlier round of
It is
litigation.
not on that at all, my lord. One submission is this forfeiture of security has no problem with MCL, my lord. Only problem is with other companies, other agencies. Only that aspect. I'm ready to reimburse the 2 crores, 2.5 crores, whatever it is, and let the bid security be returned. I'm not asking for lifting of disqualification also, my lord. I'm not challenging on that also. Only request is, please consider I'm going to reimburse you this 2 crores, 2.5 crores, whatever is there, the legal expenditure. Kindly return my bid security so that I can participate in other tenders. That's all, my lord. Only to that limited extent, my lord. Nothing more than that, and I'm not seeking any concession in that matter at all, my lord. I'm going to pay, even though it is.
But 2.2.1 talks about the forfeiture of the bid security as well.
May I just make one submission, my lord?
So,
My lord, after the writ petition was dismissed by this honorable court, I made a representation to them. Then they considered and they said, we're not going to ban you. Then only the disqualification was there, followed by forfeiture of bid security. Then I went to Supreme Court. Then the matter was remanded back. Then honorable court said, please consider.
Achha, oh.
Then the honorable court said, please consider the returning of the bid security, not disqualification, my lord. I'm not on the disqualification at all. I'm disqualified. I agree, I accept. Only thing is bid security. If MCL had no problem accepting my tenders, then other agencies, it is indirect ban on me with other agencies. That is the only grievance. And one tender which I have filed, it clearly says that disqualification followed by forfeiture of bid security. And even MCL, Coal India, everybody is accepting my tenders. And in fact, MCL has chosen not to ban me considering my performance.
No, that is what is there. The disqualification also, they said that no, definitely not. Blacklisting, no.
No, only.
That's all. Only thing is disqualification in this tender is concerned, that's all.
No, I'm not asking for removal of disqualification also, my lord. I don't want to be removal of disqualification. Only thing is...
You are ready to participate. You go anywhere you participate. What is the difficulty?
The problem is this is the condition precedent, my lord.
What condition?
Saying that should not be disqualified, followed by forfeiture of bid security in any PSU. Any PSU, my lord. Any government organization. So that is becoming a hurdle for me. And I am a successful contractor even for MCL also, my lord.
Why you are not reconsidering the release the bid because your contention is that whatever this will not be treated as a penalty.
No.
Your clause also says so. So why it will be imposed as a penalty?
You fix up a timeline.
Is a kind of a debarment. How can you do that? You are entitled to get reimbursement of the entire actual cost which you have incurred. Why don't take a cost and then go?
Lots will pass for this. Lots will pass up orders accordingly.
You will not consider, pass an order accordingly. Everything should be shouldered on the court. Your lapses, your gaps, your lackadaisical attitude, you pass on to the court. You do it. You will remain silent. You will remain dormant all the time. Unnecessarily, litigations are pouring in the docket of the court because of your this kind of an attitude. There was already a direction in an earlier writ petition to reconsider. Still, you have not been able to reconsider.
His fourth prayer was also that.
Huh?
His fourth prayer in the writ petition was also that. Okay.
See? The writ petitioner
The idea I have pointed out, one company may not NLC India.
Nothing, nothing, sir, nothing, sir.
Yes.
In view of the observation, the IA becomes infractuous accordingly.
Item number 1.
They have.
No, let them decide. Let them decide.
And any observation will undertake. And our
We have not said anything on that.
being undertaking this. They are about to start.
That we can't.
But whatever damages they will say.
That has already been done. Let them take a decision. Otherwise, that will be, because the observation is whether it will continue a debarment in that sense. That has to take a decision by them.
We are.
We have to take a
Today is the last date. We are ready with the
No.
and already.
No, not now.
Under the bill security.
We have given a very shorter time to do it. It's called the.
Item 1. Watch this.
One is the decision taken by the opposite party
Blacklisting you for 3 years.
for 3 years without.
What you have done?
That is annexure 4, but before coming to the annexure 4, in Nursery come to annexure 1, what happened in this case? E-auction for allotment of catering stall at Bhubaneswar railway station, the petitioner was the highest bidder. And this auction was reserved for scheduled caste women. Petitioner is a scheduled caste woman. She became the highest bidder, and 94,000, if you also look into the
At the bottom I said,
bottom.
minimum bid value required.
That was deducted from my bank account, madam.
Okay.
But the auction was cancelled.
Hmm.
Though verbally I was intimated that I have given the wrong affidavit. Some made false declaration in the affidavit.
What was declaration?
It's 27. It's 27 paragraph.
I am asking him, he will not respond to it.
Catering stall.
She's already running a store.
That she came to know when the auction was held for very same unit for the second time. She again participated, filing the correct affidavit. She was told she became the highest bidder. Again, 94,000 was deducted, 95,000 was deducted in Annexure 3. Then she came to know that he has already been blacklisted. He was for 3 years.
But that tender was cancelled or what?
Tender was cancelled. First tender was cancelled. He became the highest bidder. Amount was deducted. Then
No, tender was cancelled after the debarment or before the debarment?
before the department.
Where you have stated?
So, madam, what happened?
No, tell me when the tender was cancelled, give me a date.
Subsequent tender is not cancelled. Initial candidate filed a
Sir, I will tell you why I am asking this question. When the earlier tender was cancelled, which contains that particular so-called mistake, typographical mistake at your end,
Because this is online, that is on the very same. Well, the second tender was agency participated.
Sir, you are avoiding an answer.
First tender was held on 29/2024.
20,
9/2024.
so 20th September 2024.
Yes, sir.
Sir, then second tender was floated when?
5/12/2020.
Right.
Till 5/12/2024.
Is there any decision communicated to you that
No.
the earlier tender is cancelled?
No, nothing. Nothing was cancelled.
When this 25/10/2024 order is communicated to you?
This order, that department was communicated after the second auction. After the second auction where I participated, I became the highest bidder.
When, can you repeat the date of the second tender?
5/12/2024, Annex 3.
That was the date of the tender. When is the date of submission of the, last date of submission of the?
Only 15 minutes, whether that is e-auction, so on the very same date.
Only one day is given for submission of the application. So,
5/12/2024, on the very same day.
no, it must have been uploaded earlier. There must be a sufficient time given for participation. You can't say that I have uploaded 11, I will close at 11:15. No.
But so far, I do submission because what I have said that admitted in the counter that I have participated in 2 tenders, I became the highest owner, highest bidder, and amount was
So
deducted.
the question is not that.
Yes.
The question is your conduct. Why I am putting those questions is you have admitted that you have given a false information. You have taken a shelter that it was a bona fide or a typographical error. It is a typographical or a bona fide or ministerial error. You took a shelter that there is no prohibition that existing stockholder cannot participate. You say that their rule says that up to 5 catering, 5 it can be done.
Yes, I
So
know.
you wanted to say that even if I disclose, I could not have been disqualified. Sir, what do you understand that I did not understand?
Yes, ma'am.
I understood what you wanted to say.
Yes.
In order to eradicate that, I am asking you this question. You are challenging the department order. You participated saying that it is null.
His name. Yes, ma'am.
Saying that it is null.
Yes, ma'am.
You said that the earlier bid was cancelled. Cancelled before the order, after the order is a question. If it is before the order, then they have to answer that why they are taking this step when the tender has already been scrapped before the participation or opening.
Since my difficulty is that probably I am not able to convince your lordship. My difficulty is that here nothing was communicated to me so far.
I understand. Now you are taking a shelter, even if I have admitted. Even if I admit. But there was no opportunity of hearing which was given to you.
That opportunity and also the order.
You say no show cause notice was given.
The order was
Show cause notice was given to you.
no.
You say no show cause. So it's a clear violation of the principle of natural justice.
Yes, ma'am.
This is your stand is.
Yes, ma'am. And your lordship may turn to
Now the question is
Will
that
not turn the annex.
what is the prejudice that is caused? Because now there has been a departure that every violation of natural justice does not tantamount to interference of an order.
Your lordship may
You have to show prejudice.
My lord,
You admitted that you made a wrong information. Admitted.
yes, ma'am.
What opportunity? Only explanation, mistake, typographical.
Yes, madam. What happened? 5 units, even if I would have disclosed it, it would not have affected the decision. Had it been disclosed that I have won the.
So there are two aspects. If there is a false information which is given, whether you wanted to deceive them you wanted to gain by virtue of this particular wrong information is a secondary aspect to one extent. The question of a benefit or the advantage, I understood where you are heading. You say that if I do not gain by that, then why it will be projected against me?
No,
Because there are already a 5 projects one can run. So there was no difficulty if I disclose also, that's not a gun disqualification.
disclose that I have one sum. That in the second way also I have disclosed that. I came to know that for this reason I have been blacklisted, debarred. That I came to know after participating in the second tender. Otherwise, I would not have participated. That is for the authority to consider.
That is
But
what,
my
that's why I am asking 3, 4 pertinent, you are unable to give me a date.
Because I was only communicated after that. That is
Sir, I just wanted when they cancelled the earlier tender, it is after the participation or after this order of blacklisting or before the order of blacklisting, I wanted to understand
before the order of blacklisting.
where you have stated, what is the date? Don't say something at the bar on the query of the court.
Only I have stated in paragraph 4 that but the auction was cancelled, the petition was intimated orally by the authority that the petitioner could not be awarded with the contract as the affidavit submitted by was found to be.
That is after, that means after. That means after.
But order of blacklisting was.
That is a different thing. Order has been passed anyhow. Yes.
Well, let's say you file the counter. Specifically one letter dated 25/10/2024, October 2024. That letter and contents I am reading that. While participating in the e-action against e-action, the national charges are dated 4/9/2024. The catering stall of the platform number 4 and 5 between pillar number 30 and 38.
What is the later date?
That is 25/10/2024.
Sir, it is there in Lecture 4, they have annexed.
Yes. That letter specifically we have stated that you are become the highest bidder. But during the verification document uploaded by you on the IRPC portal, it was found that you have submitted an affidavit 19/9/2024, so affirming that you are holding nil such events such and such. Then the last paragraph, that's why you are explaining that. Therefore, the para 2.21 and 2.22 of the special condition of BHN, the mining catering unit such and such, that you are hereby debarred from participating for the allotment of catering until June railway such and such period of 3 years such and such. Because here is a case, yes, because he has given nil, the tender was footed and he became the highest bidder.
What was the basis of this finding that your affidavit contains a false statement?
That is annexure 3 of the repetition, as you may see, page 16, affidavit.
Annexure 2,
Annexure
page
2.
13. Yes, sir.
Annexure 2 I have admitted that I have
And the circular who was cited upon to us, this is not a correct circular. The correct circular is coming under that is full form from non-fair revenue circular, that is circular 9.
Just that is 6.
Counter is
Black 10.
black.
10. It is visible. Whatever comes to you, you just help us with the file it. You don't click there. How should we read the argument line? The assistant the can you read that? Please come to page 35 of your staff. Please tell us. Just probably a lot of home thing. And it's very
Will you a type copy? Sorry.
part of the problem. That's why I'm asking Mr. Kasher.
I can give it.
How can you read that?
No, it's just impossible. This I'm considering my doctor.
Where is that clause you are invoking?
It is
2.21.
it is for 22 point.
Oh, 2.21.
Yes.
Yes, please. Where is that clause?
That is that is based on T, continuing as 48 or a counter affidavit.
Page.
Page internal page 20, only continuing page 48. Then basic 2.21.
No.
Events of default and oblique material breach. Then let's come to C. 2.21 C.
If the railway finds
Yes, ma'am. Correct. If the railway finds that the bidder has obtained this license by giving false information or details in the tender process, at any time the railway has a right to annul the license and terminate.
2.22.
Yes. Let's make come to 2.22 is penalty. Next page. Page 21. Yes.
plus C.
Clause C. Divide the B, C, and the to annul the license and put it the termination of the license. Then they debar the license from participate further in allotment of the catering units or any zonal railways IRCTC for a period of 3 years. That's why either blacklisting or debar. We have given the debar, not blacklisting.
Same thing. Almost the same.
Debar oblique stroke oblique blacklist. That too, we have debarred from the particular zone only. We are not debarred all over India. You will participate anywhere. We have not done this. Only he is continuing in the earlier work. He then multi-party you is allowed to give. Continue in this.
You can't touch it anyway.
Yes. Yes. That's why we will not.
US as a what? Further in allotment.
Yes. Correct.
So you can impose only further allotment.
Not yes. Yes. That's why she is continuing in multi-party.
Isn't that one only you are dividing?
Yes. Yes. That's why we have specifically said that the allotment of catering on any zonal railway IRCTC for a period of 3 years.
Page 24, madam.
Eastern honest
Why
man.
you do not issue a notice that this is what it is? That you come and explain.
You will also come to page 24. madam.
You do not. Will you not?
Page 24, it starts from annexure 6. It starts from page 23, policy for commercial earning, non-fair revenue contracts awarded to
Everything is uploaded in the portal. So there is no question of giving any correspondence to anything. Because knowingly uploaded their documents and they are verified on their own level, we can verify after.
They are not disputing their allotment at page 6, para 6 of their counter. They are not carried any objections or reason.
So for annexure 6,
Para 6 of their counter. Last line.
Right, this is contrary to what I said. Even accepting that they have communicated, even accepting that they have communicated the blacklisting,
2810, they said it.
even they accepted it for the sake of argument.
And you did not.
Pardon, my lord.
What you have said, where you have said in your affidavit that you, that,
Or not received, or that is not the address or correct address.
what you have said about this communication.
Communication, my lord, I have said that in my
Because the importance of reading in a adversarial and judicial system is very important. So, what I have treated.
I have said in my counter, in my rate petition, my lord, that in the second action, after second action, there I came to know that I have been blacklisted. Otherwise, I would not have, that is obvious from the obvious inference from that I participated because I was not aware.
Sir,
Yes, my lord, I
registered post and the address which is shown in their document. The same address you have given in your process.
maybe subsequently I have.
I've seen plot number 1124. And there, annexer, there annexer E, P2C. That is also plot number 1124. Address is correct. Address is same.
With my humble submission before my humble submission before a lordship is that, my lord. Your lordship may come to page 24, annexure 6. It starts from page 23. Policy for commercial earning non-fair revenue contracts. Page 24, paragraph 30. But your lordship can see the circular. They say there is no provision for giving notice.
It is the wrong circular. We are not referring that circular. It is circular, it's combined to us.
They say only about why I am saying that. They say that the circular which I am relying that you should give prior notice, so-called notice under annexure 5, that is not applicable, they say. So for annexure 6 is concerned, they are silent. Annexure 6 is the correct circular where it says that banning of farms, right? Paragraph 30 at page 24 of the writ petition, your lordship may see, there the procedure has been given. If your lordship come to paragraph 30.4, any bidder contractor shall not be debarred unless such bidder contractor has been given a reasonable opportunity to represent against such debarment. So this circular is very clear, and this is also applicable to the present case with my humble submission before your lordship is that. And further, my lord, and your lordship knows in several cases, the Honorable Appeals Court or in that Gorkhas.
Yes, and in those cases, the court has also highlighted if prejudice could be seen to have cause, then in that event, mere technical violation of the natural.
Here, my lord.
What is the prejudice? I'm just asking you, suppose if you go there after giving a notice, you have already admitted that you have given a wrong or information. You are taking shelter under a mistake. It is a mistake, bona fide mistake. But there is a false or a wrong information that is admitted. If they say that a motive cannot be a ground, if there is a false information, it will invite a debarment.
But at the same time, if it is material breach of contract, I can hold one can.
Now again, the question of, I'm saying the question of implication takes a back seat. The question is whether you have wrongly informed or not.
It is a E option.
Whatever. So you are talking about an intention.
Here, my
It will be absolutely ideal exercise because you have admitted.
I have taken all this time in annexure 8 before the authority.
What is the question? Of relying subsequently.
You'll also kindly see that
Yes, we have considered this and we are relying on that. The question of prejudice will also come.
Yes, here it says that it amounts to civil death. So any order.
It is civil death when in Gorkha, even in the Panda infrastructure subsequently that has come. The court says when it is a permanent debarment, it is a civil death.
Let them consider.
If it is for a definite period, it is for a definite period. In Panda infrastructure also, it was an extreme case where the entire chunk of, the high overbridge fall,
My lord,
causing a death of several persons.
my lord, so far the paragraph, my lord, page 24, paragraph 30 says, if you have made false declaration, then you will be banned for 90 days. You know, look into the
I
paragraph.
have seen that. It is.
They don't say, my lord, they don't say that it is not applicable.
No, I have seen that clause.
Let them consider, my lord,
30.1
my lord, let the authority consider.
30.1 applies. We are seeing that when it applies.
Well, 30 point that relates to banning of farms and also giving the procedure to be followed, my lord. Procedure to they don't dispute that, my lord. And super local services, my lord, I am given, my lord. And there are also another decisions. 2021 to SEC, I say one also. And also another there is
When you did not read our judgment.
and also this honorable court decision also, my lord,
Our judgment.
my lord, Honorable Justice Raman is there, my lord, in the division bench. I think this is totally huh? My lord, so far the blacklisting is concerned, the authority to consider whether my mistake is substantial, that is intentional, or that let them consider it. I have already given my representation before them. They have also not issued any notice. That is for the authority to decide, my lord. Because that aspect. Paragraph 16, 17 and 18, madam.
in the next hearing of this court. Not the correct proposition. Even we have failed, so you are not coming with a 2026 judgment or a 2025 judgment. I'm delivered in 26 or 25.
I'll check out now.
We have considered all of this, Gorkha, illusion, Panda, everything was considered.
Well, my really humble submission, I know, but my only humble submission is that, but let the authority, that
Yes.
they have to take the final decision, my lord. Consider, no notice was given, only that is my only submission before you. So far, merit is concerned, I do not want to say anything because everything are on record, my lord. But admittedly, they have not issued any notice. As their own rule, even if accepting that there is no rule.
अरे लक्ष्मी रेफर की आता करो भैया इसमें judgment. It's July 2025. That case everything will be ready.
No, that's why I say we have considered those judgments.
Let me check my documents.
What is this? Atatya, what is?
Atsatrano Mia, his judgment dated 24 July 2025. WPC number 37383 of
Both of
2025.
us. You're citing a judgment where one of my brother is there. So that is a judgment where both of us are. Gorkha also, the question of exchange was argued by the Solicitor General.
My only
From
submission,
paragraph 32 onwards, the court has discarded for two reasons this was made, that prejudice will not come into play. Because there's the facts that involves that whether there is a possibility of a lesser debarment or the extreme debarment. There the court says that it caused prejudice if that is not considered show cause. Court has also considered in Gorkha that no personal hearing is required to be given.
but at least
Question is again I'm saying all these are the observations of the Gorkha. If those are to be taken into consideration, the prejudice part what? Here we have seen the clause 22.222. It does not give them any kind of a relaxation or a discretion to impose a lesser punishment.
I'm
It
not,
says immediately 3 years you have to be debarred.
and it's not a question of lesser punishment manner. That very issue in paragraph 18 of the Gorkha case, they say that there the argument was that there was no provision to give opportunity of hearing.
No, probably you could not get me what I'm saying. I know, and in the first paragraph it has been conceded. If you proceed Gorkha, the first paragraph there was a concession from the side of the the state. Yes, the natural principle of natural justice cannot be dispensed with,
Only thing, my lord,
even if there is no provision.
my lord, accepting for the sake of argument what my lord's friend says, my lord. Here is a case, my lord, they don't dispute.
I've seen it. Special provision. I know. I will also deep stress I've seen.
Humble submission before lordship is that, my lord, in the counter, they don't dispute Annexure 6, paragraph 30. They don't dispute. They said the rule is not applicable so far Annexure 5 is concerned. They concede paragraph 5. Paragraph 6, Annexure 6, paragraph 30, they remain silent. So specifically I have said this rule is applicable and you have to give opportunity to flip. Let them consider, my lord.
Additional agreement you are giving other details. I think additional agreement you are giving the entire.
My learned friend also, while
Not in piecemeal manner, the entire rule has been filed with the good by way of affidavit.
they don't consider it so far that Annexure 6 is concerned. The lordship may say additional, they don't say anything in the main affidavit.
What was the conditions which are incorporated in the RF? You will go by that terms and conditions or some other terms and conditions?
The procedure for debarment, the punishment is there that if you breach, there is a breach of contract, you will be debarred for 3 years. Just like in criminal justice, suppose the conviction, the sentence, minimum sentence is 1.5 years, or that cannot be reduced. But he has to be given opportunity of hearing. That is my humble submission before your lordship.
The question again, I am saying, you are taking an analogy of the criminal case. The criminal case says it should not go. That is the minimum sentence is there, and up to a maximum sentence is there, and there is a discretion in between a minimum and maximum. So then, once the discretion is invited, then an opportunity must be given on a basis of a quality evidence which is towards finding a guilty and sentencing a person to different concepts.
But here, my lord,
So here there is no relaxation.
but here they also admit in the counter, they have given that
If
one
like
can have
this,
maximum
up to the period of 3 years, I would have admitted. I would have accepted.
here,
It simply says for a period of 3 years.
here, my lord, they admit in the counter that one can have 5 catering units. That they have admitted in the counter. They have given the circular also. So let them consider, they may lift it. That is for the authority to decide, my lord. And before passing the extreme order of debarment,
Apart from this one submission I have, this it was already been alerted to some Jagannath process like this, who is
that
already took over the work by quoting 19 lakh somehow.
The bargain is not challenging. I mean, the rejection of his bid in the second tender is not subject matter of that.
Yes.
We will not interfere with that.
Yes.
Only thing is that so far as the department is concerned.
Yes.
So it will always have a prospective effect, not a retrospective.
Thank you.
Is a prospective
Well, I want to check off this my lord's order, but I have not seen that. My lord is referring to Brazil.
We'll consider it.
Only thing, my lord, will also be
No,
considered the only aspect. I have nothing more to say.
No, because you have said it. The public, for orders in the next meeting, which was. Indian gas supplies.
Item two.
Second of the litigation, challenging the order of the first the Grimsar Bulla, the second is the SCB, and third is the CDMO Sambalpur. They have all rejected my recommendation to provide the manpower for giving attendance to the destitute patients in their hospital.
Three
What should be-
methods have come today with us. 1, 2, 3. With one case we have filed our counter and two other cases counter have not been filed. May I pray some time for filing of counter in the rest of the cases?
You are doing.
We have 27 numbers of OPLE proceedings are initiated already.
What was it over?
Yes.
The present representation in the nature of the public is prosecution
What is this receipt?
Receipt one, Annexure 1 has been filed in a grievance cell. They are issuing a receipt.
Where is the annexure one? Annexure one is a, that is what I am saying.
At page 11.
What is this? Page 11 is your representation.
My lord.
Why don't you give a translated copy? I can't read this. What do you expect from me to do?
My invoice where the opposite party number 4 directed to dispose of things.
Why? What is your right? What is your right?
I would have given these fisheries for villages.
First, you tell me what is your right for which you have approached the authority. What are the rights?
Forest land in the village of the petitioner manor, opposite party number 8, he has taken the land, forest land, and has made an agreement to sell the land to opposite party number 9.
No, if it is the government has decided, it is the government's policy decision what to do and what not to do.
Now, may I please, my lord, when I get the information under RTI Act, my lord,
Sir, under the mutation proceeding was there, ROR has been corrected. If you have any grievance against the wrongful incorporation of the name, then in that event, the committee of problem, another act, you can take reports to that problem.
my lord, you may bring, my lord, I have got the information under RTI Act, my lord, the office has provided there is no such
If there is already a transaction in respect of a property, if the transaction is bad, civil court will take care of this.
They have specifically mentioned.
Sorry. There is no public element involved in this. This is absolutely a private litigation.
No, may I please? They have published letters. There is no such case record available with the office.
No, everything is available with them. It is their headache. They will take care of it.
Well, they have given specifically replied on page 21. So categorically mentioned that no such case record is available with the office.
Where is the act concerning this correction or entry in the record of rights? Does the Land Reforms Act or under any other act?
Well, that is under Odisha Service Settlement Act.
There is a provision relating to the correction of the wrong entry in the record of rights.
Let's look at it on section 15 of
1.5.
1.5 Odisha Service Settlement Act. And the instruction says that in 1998, one revision petition was filed.
But it is a finally copy of the record of rights.
Yes, Lord.
There is no power. Section 15 does not apply.
But at 15B, or 15B,
The final publication has been done, the limitation period is given 1 year. The final publication has already been done under section 12B. Then, has he approved within 1 year?
He has not approached for it. So one summons writes in whose name the land is recorded. That is recorded as per the order passed by the commissioner settlements under this proviso 15B. Now he is challenging that.
It was on the basis of the order of the civil court, judgment of the civil court.
No, Miller. Basing upon the order of the commissioner settlement under this proviso.
So the representation, they are asking for certain information that is provided to them.
Yes, Miller.
That is provided to them. This is the instruction we are passing on.
Yes, Miller.
So if they want, they can go under 15B.
Yes. 15B also Miller, section 32 Miller. Section 30.
Or an appeal against the order.
Section 32, let's see, kindly see.
32 means your power to call and revise the proceeding by the revision officer.
Yes.
Is there any power for provision for an appeal?
No, Miller.
Because it says where no appeal lies.
Then read petition.
No. There is no provision for an appeal. Before the further higher authority.
Against the divisional order, Miller, there is no.
For publication of final.
Well paid.
Only 15B.
Yes. Yes.
This was the proceeding under 15B. Yes, number. Well, so against this order, what to do?
You sought for certain information with regard to appeals. Right? And the order by which the jungle zone is that information has already been given to you. This clear application was exposed. Yes, this is the information that sir, this is the information given to you, sir. On 19/4/2025. 19/4/2025. Pratap Samantha?
It was first.
Pratap Samantha? Yes.
No. Yes, obliged. This information was provided to me. And as for this information, the officer, by virtue of this order, that ROR has been created. Second information, my lord, I have sought for getting the certified copy of the document of that ROR. Arbitration. The office provided no such case record is available with the office. That revision case matter. By virtue of which that ROR has been taken. No such document, ma'am.
Where is that?
So if there is no document, then they will create a document for you.
No, because of case is there, but 21, ma'am, at page 21, ma'am. Specifically, stated, ma'am.
This is third-round litigation.
Very interesting. Which organization is taking records to the old?
Minor.
Which organization
Yes, right.
is taking that old spelling?
Yes. I'm coming.
Which one is?
Yes, I'm coming.
Continuing.
Only 1 minute. This is third-round litigation coming to this alone.
No concern.
Third,
Where is?
I'm answering that. Third litigation in the WPC number 2625/13. Second, after 4 years, 15,854 of 2017. Who ordered? Litigation report in 2013, there was no change. But in the meantime, after 2000, when the second round, the same with the same prayer, part of file in the year 2017, that time, Chennai was renamed as Madras as Chennai. Orissa, our own state. Orissa became Odisha. Bombay became Mumbai. So many changes, colonial.
I am also not spared. I came from the state where also the change has come.
Yes,
so far as the,
yes.
But still the Calcutta High Court remains.
Madras High Court,
Kolkata.
not Chennai, all these things. High Court normal not change. But I am not coming to that.
Now it is within the wisdom of the authority whether to embrace those names.
No, minority.
To embrace.
Let me say. I am not praising the High Court, but minority said getting.
Okay. Now, why I am saying so?
No, I am not praising for High Court.
Sir, please,
yes.
Sir, if you do not listen to me,
I am for the same time.
I am that is what I am getting at.
Yes, please.
That it is within the wisdom of the authority
Yes.
to take a decision that what spelling they will accept.
Yes.
So far as the High Court is concerned, it is within the wisdom of the High Court to see whether they will change the name from Calcutta High Court to Kolkata High Court. The authority have decided not to change the name.
Yes.
Similarly, if the state has decided not to change the name or to spell in a particular manner, whether the court or the public interest litigation lies in this name. That is why Justice Javeri's judgment is before me at page 21. It says that it is within the prerogative of the state whether to spell Katak as Cuttack instead of Katak.
Yes.
It is within their wisdom.
Yes.
You can't impose no. The Katak must be spelled Katak.
Yes.
You can't write it as Cuttack.
Yes.
What kind of a litigation is coming before this court?
No. This is a valid litigation. I think I am not
You say no, it should be Katak. That's the original one.
It is not.
Why you are using Cuttack?
I know it is not. I am saying the document, the old documents which has been buried in.
Many, sir.
Kindly bear with 1 minute. Why I am telling? What is my background? Not that I am coming and approaching what documents I have. Why I am submitting this?
Sir, it is
there is some background.
The only query is, or I would say observation is, it is within the prerogative of the state.
Yes, sir.
To spell.
Yes, sir.
They cannot entertain any public interest litigation.
Madam,
Want a publicity tomorrow?
No. Publicity, it is the third round litigation coming.
That is why the publicity is more.
Not publicity. Why this time I come to give for minor? Madam, 1 minute, 2 sentences. Why I come?
because now government is
Earlier
going to
decision-
now annexure 10 lakh.
Earlier decision dictated
Much stated, I am confident. The first order of 2013, dated 26th July 2013. C. Nagapan Chief Justice, I am the judge. They told, considering the fact that the case will deem it fit to direct the petitioner to make a representation to the government of Orissa, represented by the Chief Secretary, because earlier I had represented to collector. So the Chief Justice on that day, the first PIL, Honorable Court, the Chief Secretary, instead of collector, you should represent to Chief Secretary, and in the event such a
Now I am
representation is made.
asking, is it a correct way to decide a PI?
No, these are only backed by this court.
I am asking you, sir.
This is the order of
What is
this
your
court.
view?
Mind you, this order of this court, not I am telling you. This is quoted by the C. Nagapan, page 19, on annexure 4. Then mind you, what says Javeri told that in unconstitutional prerogative of the state. It's okay, madam. But why I came now again? My lord,
No,
let's finish.
No, not only that finding. Another finding is the division.
Yes, sir.
It doesn't fall within the ambit of common.
It is not common fund,
Huh?
but it is not any personal cause. The change of the
Sir,
name.
That finding.
Sir, it is not a personal clause, but it is a publicity claim.
It is not published, my lord.
It's a publicity.
No, it is hurting our citizens because my home is at Cuttack district and Cuttack was the capital of the country, our state. Because of the, my lord, the John Beams was the first collector of Cuttack. He has total several.
Still the government has
No,
declared this
government will take decision. My lord, when government is not taking decision, judiciary having ample power to review any decision of the government. Why I am coming this time, not for public, but why? Very recently, by Annexure 9, government has published a notice, public notice, by changing about spelling of English 11 names. They need to, now 29, 24 names. Spelling of, turn to Noyagad. It is written as GARH. So government is taking a decision to make it GA. Suppose Athagad. It is GARH. So government has taken, no, it will take as GARH. Annexure 9. So when government is in process of changing 20, making correct spelling of English spelling of 24 names, but sorry, state of Arts Cuttack is not in production. Only the pronunciation, Noyagad, GRH, they stated Noyagad, minus 3 Annexure 9. Then Athagad, GRH, they put GADA, making the English as per the pronunciation of the place, the spelling is government is making and asking for public notice.
Let me understand. My English is very bad.
No, English.
How you pronounce "ka" in English? Is this only the K which denotes "ka," or it is C which also denotes at one point of time as "ka"? You can't say that the "ka" has to be changed. Now, when you use the English language, then "ka" can be described or can be expressed in what manner? Can it not be expressed with C?
Yes. But
Can it only be expressed with
Yes.
K?
Yes, my note is correct. But
So-
now the present spelling is not cut off, it is put up. It is not cut off.
Sir,
Its
I do
English
not
spelling
know.
is very, very different.
Sir, how you pronounce CURSORY? How you pronounce Kursari or Cursary?
It is not a question of minor.
Are you pronouncing
No, madam.
CURSORY as Kursari
Minor,
or you are pronouncing as Cursary? Tell me.
Because
Does it
your
cursor?
minor is correct.
So CU does not always mean is a Q
No.
put up.
Yes.
It always can be cut up.
Yes.
So there are. How you pronounce?
Minor. Why I say? Minor, why I say so? Minor, why I so?
My brother has another logic.
No, yes.
How you pronounce CUT?
Yes. I am not telling.
Good.
What?
How you pronounce?
I have come to your lordship center. Haircut. But then my
CUT. How can you?
yes,
You
yes.
have to pronounce as good.
Kindly ମୋତେ ଟିକେ ଶୁଣନ୍ତୁ fact ହେଲା I am not telling from my side 1917 when Britishers were ruling Qatar India, that time a matric certificate which was the highest education at that point of time, and the matric certificate issued to this legalized Patnaik Annexure 1 by University of Calcutta. A University of Calcutta is issuing a matric certificate. Spelling is K-A-T-A. I am not talking all the thing. It is a document, public document, government document, university document, what I have annexed 1. Number 2, a Mughal period map.
Sir,
Which
my ancestors, when they had certain certificates, even Calcutta was not there. It was used to be a Calicut. Calicut. Are you aware? Then came Calcutta.
Why I am
Then came Kolkata.
Why I am telling Kotak? Why I am telling Kotak is
So all these certificates.
Yes, that is minority
Calicut, sir.
Calicut, sir. But why? What is my argument? Minus from matric certificate. You are the highest. Matric. You are the highest. Minor matric.
Two PM, but it is a Friday. My Lord generally sitting is a single bench. So then it is 6th of May.
Fridays are actually, I said singly because of the arbitration matter, section 11 matters.
Or
My
6th.
anxiety, I'll tell you, Lordship, the anxiety is, this was the section 36 order. In where the award debtor was directed to deposit the entire amount. Here the award debtor is the East Coast Railways. Against that, they had filed a writ petition before a learned single judge of this honorable court. The learned single judge has passed whatever order the Lordship could be considering it on merits. But there is an observation for which we are apprehensive that the CEI may take up investigation of this case. Though there is no investigation pending as of now. But that part, if my learned friend could assure that till whatever your Lordship feels.
My Lord, the case of tender is 75 crores, the award is claiming of 4,000 crores, award is 1,800 crores. So this is the reason being this honorable single judge has passed an order basing on the decision of the Calcutta High Court, then Division Bench, then Supreme Court.
No, those orders have all been set aside. The orders which have been set aside is being looked into now. Number 1 and number 2. A consent order of the Supreme Court is
Sarab's order.
Justice Sarab's order. Now, both Justice Sarab's order and the Division Bench order of Justice I.P. Mukherjee, they were all set aside by consent of the parties before the Supreme Court. Now, we are the learned judge.
Appointment arbitrator, that's why they are a single arbitrator appointed by Supreme Court. It is not that each cause or any merit it was decided.
Yes.
So let's say fix on 6th of May after 2 PM.
Your Lordship, I will have a look to your page number 96, which is open before my lords. Where the paragraph is at paragraph 71, which starts at page 70.
When you want, just tell us. We want.
Give us a date, time.
We don't have any objection for 1st of May, but only I let in the court that the Friday is after lunch, generally my lord is sitting a single. That's why I'm let in the court. Or in the 6th of May, if there is no inconvenience to my learned senior.
Why not before that?
Why not before that, we don't have any.
The small matter concerning section 36.
Yes. It can be hard It will not take more time, man. Please.
Or if your lordship permits,
Is it against the interim order or a final order?
this is a final
34
order.
is pending. 34 is pending. Again, 36 we have come.
We have not
34 is pending, my lord.
we have not yet filed the execution application.
Then why 36 you said?
But in 36, my lord,
That is what section 34 application filed.
34 file,
And 36.
36 file. In 36, my lord,
Interim order.
yes, the learned commercial court directed them to, my lord, deposit the money, partly, my lord, by way of bank guarantee, the majority portion by bank guarantee, and the actual amount, my lord, by way of deposit in court. Against that, my lord, there is a writ petition filed where.
So that means against the interim order pending section 34.
Yes, right.
That is what I am asking
Yes, 36
you. That is what I just want
It's
to.
always in the nature of an interim proceeding, right?
So let us see.
But it-
Well, because the first question will be my difficulty, my own judgment. Mr. DSG,
Yes, ma'am.
the difficulty is my own judgment.
Oh, only unless by court there is who will take participate in hearing. The land as you will appear. I didn't have any problem. Problem is that the land as is
I stand corrected, not my judgment, own judgment, our judgment. My brother was also
My
there.
lord's judgment is a court judgment, my lord. That is, yes. In 1st of May, no way inconvenient to the court.
Or will not equal lots.
Nothing is inconvenient to the court. What is
Then
convenient to you is the main important factor.
Then 6th of May, my lord. 6th of May at 2 p.m.
That's why I say if there is no inconvenience to the court, it's the convenience of the standing councils. Tell us, what is your convenience?
If he 1st of May, I didn't have enough. The land as he has consent, given consent at 2 p.m. he will appear. No issue.
No. Virtual or physical?
I think he may join virtually or he may come in physically. Anybody he will appear in the court in 1st May. No issue.
Very well. But only thing but some observation was regarding para 71.
What is that paragraph?
But para 71 where it says, it's a general observation. It is time, if your lordship will kindly take page number 96, I don't read it in its entirety. Second line, it is time that perhaps appropriate investigating agencies such as the CBI look at such cases such as the present one, suo motu, so that the interests of the page 96. So this is open book.
Which paragraph?
Well, the paragraph is para 71, which starts at
Continuation.
yes.
Just.
Yes. Which one is this?
Understood.
We have some observation on this particular. We'll come back to
But the final conclusion is different. This is one of the paragraph where the court has observed it, but it is a final conclusion is different. Final conclusion is
insisting that was the mere observations that should have or might have, but they have not.
But that is also my understanding.
not a direction.
That is really an obiter dicta.
Right.
To some extent, it has been done.
So provided me the investigating agencies
But
understand that.
they have to seek a permission. They have to.
Yes,
They cannot
absolutely,
do it in a suo motu.
yes.
So that has not been done as of now, Mr. DSG.
yes, as far my knowledge is concerned, there nothing has been.
There is nothing. So
But kindly record that and not fix it.
what is the record?
But
Come
otherwise,
on first. If they do it, mention the matter. See.
Well,
Yes. Was I don't want to fix it.
but first, if you kindly consider fixing a time limit.
What is the time?
2 p.m. or 12:30. 2 p.m. is
Yes, 10:30.
Well,
10:30. Yes.
Yes.
Item number 40, sir.
well, only one more thing, Willard. Let it be understood, Willard, on the matter is speak before the learned commercial court. On 18th, we pray for an adjournment over there. I'm just.
There is nothing which is.
May particular time, sorry, because it's not the time to make a mention. Item 52. The item 52, my lord, the interpretation has been filed challenging. I'm not training on merit, on challenging the rule 16 of the account, Panchayat the accounting procedure rule 2002. And batch of writ applications are already filed and your lordship are being batch of writ applications. That is the why, my lord, why I'm saying that just implementation. Panchayat Samiti, Mr. Dolai, yes. Mr. Gampath. So, my lord, what I am doing, submitted this case may be attached to lordship, fix a date because otherwise all these cases will become invalid. No, the date was fixed to 12th January, but it is not. Yes, Dolai is the council there.
Yes. Can you cover civil filing in the Milan Convention? No,
So, date has.
that was there, but
Second week of May.
Already counter filed.
Second week of May.
Yes.
My lord, what I am doing, my lord, lordship can fix it time. My lord, it will not take much time. It will only not take much time. My lord, 2 o'clock or 3 o'clock, any time you lordship. My lord, otherwise it will become
You
important.
see the arguing council.
My lord, arguing council, there are many councils.
That is why I am apprehensive. That's what I asked.
But I will say that only one council will argue. We'll see that only one council will argue. No difficulty. So let's to fix a time.
Mr. Dubai must agree.
Like, no, that will happen. That will not be all the claim.
Yes.
13th May.
13th.
13 million ballot for your lordship. To
10:30.
10:30.
So,
This one. Item 40.
Item 40, my lord. I have prepared a detailed setup. And just my lord, during course of the day, I am going to file it. I will serve a copy to him. Let us.
you already, this is correct, African orders, only pray lordship, some protection by the lordship because only
My lord,
that.
yeah.
Otherwise, I am not able to participate because they,
That participation, that cause of action is normal.
you know,
Because
that is very particular that you have been divided for all, from all mark.
I know I did this. This is what counter. We are just trying.
because
Counter, we are taking this matter tomorrow.
Lordship,
okay, my lord.
Let us. We have gone through.
Submitted.
No, can it be day after tomorrow? No, one day.
Tomorrow.
No. Just now I will file it.
Matter is fixed tomorrow.
All right.
What is it?
Number 7.
There is 11 more RAMAN.
Particularly paragraph 7, taken that paragraph 7 Millard. And the prayer Millard, my humble sum 74. Lordship in some identical cases rectified it. The jurisdiction of National Green Tribunal.
Yes, we have already decided.
Yes.
This, we'll have to go to a national green tribunal. We have decided what to deliver a judgment. Where is that?
2026 ILR cut off 7-1.
Sorry, madam, we can't, but we are bound by our own judgment. We have said that once it relates to an NGT, then we'll have to go to the NGT, you can't come. Directly, you have to go there first. So similar way is to. Next.
Item number 8.
Permitted to withdraw. Permitted to withdraw.
Ma'am. Item number 9.
May I please Item 9. Here will also see a direction to the state government to strictly implement the rules framed by the state government in 2007, that is the Orissa Minerals Prevention of Theft, Smuggling and Illegal Mining and Regulation of Possession, Storage, Trading and Transportation Routes. Hello?
What are you doing? Why you have framed the rules, then you have to just modify the date of its implementation.
This rule is implemented in almost all cases. There are also demands.
Here, my lord, that is not the case, my lords. They have provided measures.
Madam, strict enforcement of 2007.
Yes, my lords. What?
Strict
enforcement in the sense, my lords, the rules are there, the framework is there. Now we make complaints about the illegal stacking of minerals at various sites, which the state pollution control board also gives a report that there is illegal stacking all over the state, my lords. But these other state government officials under the mining department, they refuse to take any action. The report of the Annexure 4, if you like.
2 weeks.
Obliged.
Item number 10.
Well, this may kindly be taken up with another writ application 397. Mal. Obliged.
Item number 10.
Item 10, my lord. I want to waive this petition. I just seek this honorable court's indulgence, my lord, in directing the opposite party, the collector Kalahali, to monitor the utilization of funds.
The earlier matter.
Yes.
So you entered you wanted the irregularity, the corruption, which is the Manrega.
I just I'm seeking just that collector or opposite party number 5 may monitor the utilization of funds, my lord. For the reason my lordship sees that page 53. Page 53, my lord. The director station projects, my lord, has communicated to all the collectors.
They have sanctioned this part of the
where it has been clearly mentioned that the government has instructed to clear only the pending liabilities for financial year 2024-25, utilizing the said fund. Therefore, we are requested to instruct all the implementing agencies under your jurisdiction to clear only the pending liabilities, that's the material component for the 2000 financial year 2020.
If there is anything which is pending, they have to clear up all the pending.
The fund which has been sanctioned, my lord, it is for only 2024-25, my lords. Thereafter, my lord, it may come to page 52, my lord. Subsequently, my lord, after the previous letter, subsequently to my lord, the collector from DPC, Kalahandi, my lord, he wrote letter to the BDO, the project director, watershed, concerned authorities with regard to my lord. It sees the third line of the paragraph. It has been specifically directed that the department letter under referred to ensure clearance of payment.
They are spent for 25-26 instead of 24-25.
My lord.
This is what show cause has been given.
No, my lord. Thereafter, my lord, this show cause has been given, my lord,
to the block development officer. Why you have utilized this for 25-26?
My lord.
Why not when it was for 24-25?
My lord, if my lord sees second paragraph, my lord. Second line. However, in flagrant violation.
Oh, that is what I'm saying, that you are utilizing this fund for financial year 25-26 instead of 24-25. So what are you doing, sir? You have to match the deadlines faster. That is what I'm saying. For that, show cause is given. What happened?
No action till now has been.
I do not know. They have to disclose that whether any action has been taken. And once the action has already been taken, then why will keep the PIL here pending?
Well, thereafter, my lord, I approve the collector with my representation, my lord.
I have a very bad impression about this representation.
I am sorry, my lord. That is.
What are you doing?
Regarding this, proposed notice has been issued.
True, that was in 3rd of October 2025. Yes. But now we are in a month of April 2026. So more than nearly 5 months, 6 months have elapsed.
We find out. We find out whether to have responded.
Item 11.
In this matter, I am the open for number 6 panel.
Mr. Soloy, we are stuck up with our own judgment. What entity?
I'm not.
You are felling off the trees, ecological imbalance.
I am not.
Which really
I'm not in that
changes. Everything is there.
No, I'm not on that. So.
You are. Your prayer is on. If you are not on that, then petition deserves to be dismissed because your prayer is that.
But let's see here. Let's see. Can you say
your prayer is simply that. That in a coal mining areas, they are felling a lot of trees. They are creating an ecological imbalance and everything. Let us go there. The recording of forest land it will take care by this entity.
But let's say I'm not the player. I'm not the player.
No.
But let's see.
No amendment is required. You can't change the character.
No.
You can't change the.
My grievance is changed. Let's say only two.
Then the petition is not.
Only 2 sentences. I modify it. Let's say got the point. 2 sentences. Let's say I modify it. I will try to file better application. Here, under the particular act, the MCL acquired the entire land along with this high villages, lordship. And these 2 jungles, lordship, the 2 forest lands is available in between these villages, lordship. And without taking any steps to acquire the entire villagers, lordship, for adopting displacement policy, now they are trying to only acquire the forest land only. So that is our lifeline. So you have to, as per lordship,
your lifeline.
Lordship.
How?
Lordship, two forest land, Lordship, Lordship kindly see, they are giving us Axian, Oxyan and Lordship.
That's why I wanted this answer. So NGT.
No,
Lordship.
It's
again an ecological.
That's
an ecological problem. You will have to go there.
Lordship, kindly come to Annexure 1. Lordship, kindly come to Annexure 1, Lordship. Annexure 1, Lordship.
Go there.
Lordship, kindly come to Annexure 1.
No.
Lordship, for a moment, Lordship. Sorry, Lordship. Page 37, Lordship, kindly see. For a moment, Lordship. Because Lordship grant me liberty to change my prayer, Lordship. Lordship, kindly page 37. We are not on that, Lordship. We are saying, Lordship, if you have acquired our land, you take our entire land. You can, in peaceful manner, you can take only forest part.
That is also permissible. The acquisition is with them, which land they will take.
Then,
and they will not take.
Lordship,
You not impose them that you have to take the entire land.
So that's why it is clear, Lordship. So Lordship,
Then we are deciding this.
on that point,
The power of eminent domain rests with them. Now they have to take a decision which land they require, which land they do not. Acquisition proceeding is within them.
So, within one proceeding, Lordship. Lordship,
Why should we?
One notification. That took an entire chunk of land, Lordship.
And section 4, remember earlier Act 1, section 4 notification.
What?
Whole top, the area Mauja was taken, actually,
Lordship.
which consists of many villages.
Now they are not touching to the villages. Now they are taking steps only to take out the jungle, Lordship. Only the forest land.
No, in both ways.
Then Lordship said to file better application. I will change Lordship. I will
Let us see. A better application also maintainable.
Lordship.
I do not know.
Item number 12.
My Lord, a statutory commission, Odisha State Commission for Required Classes has become defined in 2nd January 2024. The Honorable Chairperson and members, they have completed their 3-year term on 1st January 2024.
So the instruction in the matter.
Yes.
Item 13.
Villager of Chalan, yes, my lord. I am a villager of Chalan, the village in the Battlefield district. I am very content the entity for implementation of the sustainable sand mining that management guidelines 2016 minutes. They are trying to lease out the sand queries minutes. Paid off implement the sustainable sand mining management guidelines 2016 minutes. Kindly have a glance over page 14 minutes and it's over. This guidance has been framed by Ministry of Environment, Forest and Climate Change Melons, Government of India. Kindly have a glance of page 18 melons. Also got it? 18. Para 8H melons. Sand and gravel shall not be extracted within 200 to 500 meters from any crucial hydraulic structure such as pumping stations, water intakes and breaches melons. Here the sand quarry is near 100 meters of that breach. That's why it does cost. Only pray that the implementation of this guideline includes.
What is the source of this guideline? So it's a legally enforceable document.
Yes, ma'am.
So the source of power to issue a guideline.
This guidance has been put up by the Ministry of
So what, it may be an executive document. Once it is an executive document, that does not mean that it is legally enforceable document. You are trying to enforce the document. Tell me whether it is legally enforceable. Court can. Are you aware of a distinction between an executive instruction or a guideline and the statutory guideline? What is the distinction? Tell us what is the source. Just show us that what is the source of this. Yes, what is the source of this guideline? If there is a rule, if the guideline is conflicting the rules, then which must prevail? Is a rule prepared by the issued by the parliament? The rule. Take instruction that week.
Item 14.
Just give us 30 seconds. 30 seconds. You wanted a refund of all those amounts.
Yes.
Which you deposited pursuant to the first auction.
First.
The second auction was there when?
Second option was held when all the details.
After 2011.
After he
And the
deposited,
earlier one was?
and there was in 2011. Once the first auction, I deposited amount on a two series. Instead of executing the.
No, I understand. Now they wanted
That is in November.
They wanted to execute the lease deed after the second auction.
Yes. After the second notification and when
How
nobody.
can you do it, sir? If these facts are correct, either you say that these facts are not correct. But if these facts are correct, once you floated a further auction notice, that means you have cancelled the earlier one impliedly. How can you insist to undergo with the execution? He did not participate in the subsequent re-auctions. You have to refund.
But in this factor, see the instruction below.
And how your appeal is dismissed by the ADA? What is the reason?
So they said that it is not maintainable because I had not challenged any order.
Where is that?
And in the under that is you will get at page 44, annexure 9.
Let us see second page and third page.
The read mallet, the counter was filed by the state government. But they had arbitrated the entire case of the petition. You will also get at page 32, annexure 7.
Sir, why don't you go to them? They are ready to give you.
Second page, second paragraph.
Hey. Underline. Underline one.
Second page.
Sir, they say everything is ready. We wanted to refund you, but you have not gone to them to receive it. Go there, receive it.
But till that, no, nothing has been communicated to the petitioners.
What are you talking about? You'll have to go there. They say you will never approach them.
It is already communicated by letter number 2273 dated 7/10/2020. Already communicated.
What are you doing?
That is already enclosed to that document. The second page.
2022, you were communicated. Your client is not giving you proper instructions.
Same address. Address were contacted and this address is sent. Address to which it is sent, which is letter. The same address.
It is already. Recording that is. And this recording is. Yes. Yes, sir. Disposing on the basis of this.
Item 15.
May I please your lordship? Lordship, the
It's a covered matter. Yes, covered. See, no, it's a covered matter. There's already direction.
Direction
of the matter, same petition and other case.
met the necessary correction. Same signature, same opposite parties, only work name different.
Item number 16.
Give us. Yes, that's what What is your right?
No, sir. It's not the right manner because we have been continuously.
It does not mean that you have,
No, sir.
you have got a vested right
No, sir.
for all time to come.
We are only there is a consider minor, sir. Because they have
You have not got considered.
time and again they have extended minor.
They need it because they have decided to continue with you. Now they have decided to go for an open tender. They can go for an open tender, participate there, why you would not? But you can't challenge it.
Well, challenge, only
You're challenging the same.
sir.
I think you are continuing. Your prayer is like that. Initial 11 tender we caught. How can it?
Well, sir, my secondary, but since there is clause for extension, let them consider minor.
Anyone you have asked for, then within their domain, if they have asked for, that means they have to take a call. But it's not necessary. Yes. The participant
issued to the opposite party number 3, Miller. The managing director, Africa Sugar, industry.
What is the last date of activity? This is the
10 one,
already gone.
10/1/2000.
So it has gone. What can be done?
Pending.
Item 17.
Yes, 16 Annex 2. So where are we?
Just give us
30 seconds.
Now,
Yes, he was declared as a successful bidder. Then why your authority, the chief construction engineer recommended for another bidder?
I need to check what instruction in this matter. From the decision.
It was in a lottery.
Yes.
You were declared successful. Where is the correspondence?
That has not been declared, openly declared, but on the date of lottery, I was found the L1 below.
No.
I am the owner of the lottery. I have won the lottery.
Where you have stated that.
Para 5, my lord. Para 5. Para 6, my lord. Para pay 7.
No, where is the communication that it has been awarded to opposite party number 5?
Not, my lord. That proposing, my lord. That is only
Where is the proposal for?
That is within their. Only I have ascertained that I have stated.
All hearsay. There is no document which is forthcoming.
No, man.
Take instruction. Because it does not fructified into the reality. 2 weeks.
Item 18.
May one thing I would say.
Interim order on.
No, man, I am not saying for interim order. That is a provision under the acceptance of it by the OPW code has para 6.3.15 has prescribed that. If the amount of put to tender is 7 to 10 crores, the GIC has to be competent authority to accept and take the final decision. That's why the GIC has to be involved.
Item 18.
To notice to the opposite party number.
Yes.
4.
Well,
18, I got a limited grievance. Kindly give us an exit.
Give us 30 seconds.
Yes. Yes.
public.
Why you are not preparing the final bill? What is this? Unnecessarily, what is already completed in the year 2024?
But they have not given the what completion certificate.
What are you talking? They have said that they have given.
It is not there in the report. They have not filed it. But I will take it.
2 weeks.
Yes, sir.
May people. Annex 3 page 46.
We have seen that.
As yours.
This is what I am saying. 2 weeks.
Item number 19.
Yes.
There is a termination notice dated 2nd March 26.
Yes, ma'am. Page 81. Page 81.
Annexure 13.
Annexure 30. And at page 81. Yes.
In the present,
Where you are based?
we have made it, my lord, may see annexure 742, page 42. So far as the present tender is concerned, it's completely blank. The page thereafter, for other tenders where we have also applied, they are updating the status.
Completely blank.
My lord, may kindly see page 42. After receiving the bids, they're not uploading anything on the website, on the e-tender portal. That, my lord, will find at page 42.
Yes.
Even today, yesterday's status we have checked, it's completely blank. But if your lordship would get a
They have to take a decision.
now, my lords may just see the next page. A grievance is this. This is regarding Khordha municipality at page 43.
53.
All the bidders, it's there, status is being uploaded, reasons are being given, including the time stamp and everything.
This is in relation to what?
Page 43 is regarding Khordha municipality.
You are for Chandbal.
We are for Chandbal. For others, we have also applied. Hence, we could get those documents. Thereafter, my lord may see page 45. Pipli NSC also. My lord may see Pipli NSC. IA also, my lord.
What?
I'll take notice in that.
Take notice.
They're proceeding with the tender.
What are you talking? You are saying nothing is uploaded.
But they are proceeding. It's a specific case.
You are apprehensive that they must be doing in the lighting side,
Yes.
in the administration side, but they are not uploading any details.
We have literally stated
They need finalize the
Give it a short notice.
they are negotiating with others without any
Notice.
Item 42.
interim manner. May I pray that let them proceed, but let them not finalize it. Let them not finalize the tender. They can proceed.
Yes.
Because we have given other examples.
I will give you an apt reply, not this in some other. Yes.
May I request?
Through the state.
By the schemes.
No,
Sorry, not to the department.
You said.
The petitioner is ready to serve the copy of the writ petition upon the
The fresh category.
Item 22.
Lordship done the caveat, your lordship, and they have not provided any petitions. And the caveat, your lordship.
Oh, you have all the caveat?
Yes, your lordship.
Why you are not serving the copy of the caveat? Have you got a caveat declared?
Yes, I will.
Yes, caveat is there.
Yes.
What are you, why you are not serving?
I didn't know.
Didn't know about it.
No. I don't have any notice from them.
Just a fine.
Will you find those?
Yes, your lordship.
Recorded name. Appears for the opposite party number.
Status quo, please. Go to status quo. Otherwise, I will be elevated. What? Status possible. Intending order. And how does what?
I could not understand. What?
I know, otherwise, my all man will be elected. It will be great loss.
It's a purpose.
There is the prediction of failing.
No. The purpose is that the court should not pass any order without giving me an opportunity of hearing.
Yes, ma'am.
I must be noticed before court passes it.
Yes, ma'am.
So she has not got the petition. She did not get an opportunity. But then what is the purpose of a caveat to be passed? So that's why you created a problem for interim order.
Yeah, getting it. Otherwise, I will be irritated. Till next date. I am not till next date.
I always say one thing, which I think I must be very open to everybody. Where is the order of blacklisting?
We'll see that.
Where is the order of?
Annexure 5, page 154.
Page?
154 minutes. We'll see said order of
You have read the brief yesterday night. I have not. I am reading it just for the first.
I'm so sorry, minutes.
So
Read apologies, minutes. So sorry.
let me understand first. Where is the attached list? Where do you come? Which page? Your name is reflected in the blacklisting order.
I'll take you to the exact page. Lordship, in the state of Jharkhand, it would be reflected in page number 165, Your Lordship.
165.
Serial number 18 on that page, my
Yes. Serial number 18. That's for Jharkhand. Then you are a Medhavi Foundation.
Mines. That is the petition before you, Lordship.
What is the date of the floating of the tender? What order was issued when?
22/1/2025 is the date of publication, minutes. The date of work order is 25/7/2025. And my lords, the blacklisting has also been revoked. That is what I wanted to bring on my moments. By way of memo. The said blacklisting has been recalled.
I'm glad to file a petition.
It's because of the vacations, I could not bring it on record.
I have some reservation on this memo concept.
My lords,
filing a document through memo, I have not learned that it can be done.
I'll file it by way of
part of the.
We'll file it also by way of affidavit, Your Lordship.
Right. Yes, please appear for.
It is UTSEPA, Odisha School Education Program Authority. Notice has to be issued for that.
Are you, they have a separate panel?
Yes.
There were two things which I was just seeking.
One is that if the order of the debarment came subsequent to awarding a contract, how can the existing contract be affected by that? That is the first thing which struck my mind. Now, second is that now that order is also revoked, then is entitled to some kind of a protection. Are they contemplating to award any contract?
What they did was they allotted a group of schools to me. Now they are also withholding them and allotting them to someone else. So that
Have they floated any contract?
not yet, my lords, not yet.
Not yet. So
But they have terminated and asked me to stop the execution of the present project, which has been allotted to me. I've already commenced my work. The work order has been issued, the agreement has been signed, and the work has already commenced.
giving you passing an order.
Lordship, very good can take notice.
Or then at least take notice.
Minds.
Who will sort it out? I've talked to them. Lordship will sometime after.
Pilots. The course of the day.
This will be the advocate and record. Julia, what's the good name?
Katie Mudali. Katie Mudali.
With recorded names, allotted. Yes.
Next instance.
No.
Item number 24.
Gratefully, Lordship.
I'm seeking Lord's permission to appear online. Will draw my Lord's attention on page 54.
Just
Where
give
you
us
see-
2 minutes, just 1 minute. Just please. What was your bid?
My Lord.
14.99 or
14.99, Lord. In fact, the rule of the game was that we should not quote anything less than 14.99. And if there are so many at the same rate, Lord, 14.99.
then it will be a fair lottery.
My Lord. So in this
So
case,
what has
Lord,
happened?
Lord, very interestingly, my Lord, the party, one of the parties had quoted 14.99002. So the weightage should be given only for 14.99. Rather, he's being given weightage in figure of
No, without going for a lottery, he has been awarded. Without going for a lottery, he has been awarded.
He is, yes, my Lord. He was declared as L2. In fact, L1 and L2, my Lord. L1 is the negatively. He should. I just draw Lord's attention on page 113. So there should be a lottery system. My humble submission.
No, that's true. Yes, show me.
My Lord, page 113, my Lord.
Yes.
My lord, the L1 has quoted, my lord, around 18%, therefore his rate is so low. Then, my lord, L2 is
from
something,
where
my
are
lord,
you getting the percentage?
my lord, the percentage would come, my lord, from my petition, my lord, on
Page?
page 8 of my petition, my lord. Para 10.
Yes.
My lord, the one L1 has, my lord, quoted minus 18.12, so he should not be, my lord, even given weightage of becoming of his non-responsive in nature. Then 14.99, 14.99 and 14.99. So the figure is different. And the difference in figure is because L2's they are taking the decimal points.
More fraction after the decimal.
Yes, my lord. So if the two stages after the decimal is taken, then L2 would become L1. So in figure, he is quoting 965. My lord would see 151 crore, then 965 to 28,965.
Where is a provision for quoting in a percentage?
My lord, that was the same.
OPWD code. Where is that?
Page 54 is the relevant clause.
Page?
Page 54. Page 54, madam. The amendment.
Yes.
If the rate quoted by bidder is less than 15% of the tendered amount, then such a bid shall be rejected and the tender shall be finalized basing on merit of the rest bids. But if more than one bid is quoted at 14.99, decimal up to 2 numbers will be taken for all physical purposes. Less than the estimated cost, the tender accepting authority will finalize the tender through a transparent lottery system where all bidders, their authority.
I got your point. Yes, Mr. Das, how can you, then it will be in a multiple manner. 14.990000 for infinity and then 1. What will happen?
Declare this.
How can you, everybody, 2 digit should be taken. We have taken a decision in one of the matter that it should be taken as if the third unit after the decimal crosses more than 5, then it has to be added as 99. There's a pure mathematical formula.
5 or more than 5.
So this EPS contractors,
next to integral number.
Lordship, when look at page 8 again, page 8, this DPS contractor, his quote was less.
No, sir. No, sir. It is not because it has to be done in a percentage wise. What he is saying is that if it is 14.990002 is taken, then there will be a minor deviation in the number.
Yes.
He says that you cannot take more than 2 digits.
Yes.
Straight away. You have to calculate if they have quoted, and if it is they have quoted more than 15, then you will have to eliminate. L1 has quoted more than 15, 18 point something, so you have to eliminate him. And whoever has quoted on a percentage basis, 14.99, then figure you need not have to bother. You'll have to consider on the basis of lottery. How can you allot? ₹1 difference or 10 paisa difference will create after decimal the single units differently. That cannot be done. And OPWD codes only you will take only 2 units. 2 numbers, only 2 numbers. After this is what is after that.
What should call this method next week?
Awarded the contract or going to award the contract? What they are doing, what they have done.
Declared as L1, but I think yet to award, Miller.
LOA is not issued. LOA is not issued.
Not issued, madam, not yet.
Come on Monday. The 2 days, let them come.
Listed under this heading.
It will be taken as a first matter. 2 matters I have said to come.
Deeply okay.
This priority, first of 2 matters to come.
Item 25.
To take instruction immediately.
He made treasury chal on 19th February to 20th February 2025. Before 1 month. Now they have demanded me Lord again refuse, they not renew the license, again demanded a penalty. Lord, the guideline and rules provides in case delay in application that will be a penalty will be done. Lord, Annexure 1, Lord, case 12. The my license is valid up to 31st March 2025. Lord, sir.
I understand.
Yes.
Where do I get it that it is applied in the month of February?
Lord, Annexure 2, page 14, the treasury challan, Lord, that's great.
But the application?
Is the application serial number 4. Date of application.
No, you cannot reference ID.
Lordship, just prior to that, page 13.
13, I did not get the date. I did not know.
Lord, serial number 4, Lord. Form C, serial number 4. Page 13. Yes, sir. And the
Where's the receipt of the application?
page 17, Lord. Annexure 4. This is the CDM portal site, your lordships. Your lordship, the dated 19th February 2026, your lordships. Kindly see the last page, your lordships. Page 19, your lordship. Your lordship, page, yes. February 2026. Your lordship, kindly see the last page, page 19.
Action on 20th February.
Yes, your lordship. Last page, transaction details, your lordship. Page 19. Same annexure, your lordship, transaction detail, date and time 9 February 2000. Yes, yes, blood date. E-transaction, that is the only blood application to indicate the renewal, the 10,000 to be deposited in treasury challan with the form.
I understand that you have deposited 10,000, but so far as the application is concerned, whether it is
that is 2026, your lordship. That is 2026. That is regarding I status I know of my application. That I queried. So that is regarding the
yes, what you have instruction.
No, if you have deposited, then why you will
Yes, some penalty.
next week.
How much they wanted?
1 lakh. 1,10,000. 10,000 requirement of deposit. Now they want to reach again 10,000 and penalty 1 lakh. That is Annexure 5 crores.
You applied for a subsequent year also.
I applied for one application.
So this year it has expired.
No, not me. It will be 3 years.
Not 3 years.
PWD contractor license to be 3 years. You have to apply before 30 days. That is rule 9.
How can it be done?
Yes, Miller. I'll obtain instructions next week.
Sitting aside.
No, Miller, let me take instructions, Miller. Yes.
From 27.
In this case, we are challenging the legality and propriety of the decision taken by opposite party number 1, that is the Orissa state. We are challenging the legality and propriety of the decision taken by the opposite party number 1, that is Orissa State Road Transport Corporation, in holding that the bid submitted by opposite party number 3 is a successful bid. It's our specific case that he could not have been technically qualified because he does not meet the minimum eligibility requirements.
What about the Indian What about the
I am sure you have been published. I'm sorry.
What about the financial bid?
No, financial bid matters have been opened. I think they are.
Yes. So you were L2.
Yes, madam.
And he was L1.
Yes, madam.
Then you fall back on a technical evaluation stage.
Yes,
and then saying that he should not have been even qualified for at the technical evaluation stage.
The reason why, because there is a forgery committed in the documents filed by
whatever is there. This notice, we are not going to pass any report.
Itself is the first document.
No, sir. Let them prove it. Let them come. Who will say? You may say it's a false document.
But from the records of the UPS report, I take a lot.
Nothing.
306, only one page. Only one page. May also kindly come to page 306. That annexure 9 minutes. Mirror has annexed page 306.
Yes.
This is a document that we have downloaded from the website of Institute of Chartered Accountants of India. This verification was done in High Court of 2026. The UBI number that referred here.
Number is working. It is working. Anyhow, yes. What you downloaded? Institute of Chartered Accountant.
Yes, ma'am. From their website,
Yes.
And on third column, would see UBI number. It's a 2579. This is the UBI number that they have relied upon and they have used to file the returns as well as the certificate given in terms of the eligibility criteria. Malars should kindly come to the particulars. Assessment year. It is 25-26 for financial year. The name of the opposite part number 3 is referred to the proprietor, Chandra Gupta Prasad. Serial number 6. Total turnover as per Form 3CD. It is 56 crores 78 lakhs 82,260. The minimum eligibility requirement is 60 crores, madam. May I take a lot to the eligibility requirement? And madam should kindly come to page 283, madam. What? Annexure 6B.
No. Who submitted this document?
By the opposite part number 3, madam.
So what is the forgery? If the minimum requirement is 60 lakhs, it is shown as 56. So what is the question of forgery?
Madam, 306 says it is 56 crores, madam.
Correct.
So kindly come to page 283. Annexure 6B. It is this certificate that compels us to verify the UDL number.
Just 1 minute. 283.
Annexure 6B.
Yes.
Notice this is a certificate given in terms of the eligibility condition. Kindly see it at the bottom. It is the same UDI number 2579. And the financial statement given.
Just 1 minute. 1 minute. I am unable to find out.
Kindly see Annexure 6B towards the bottom. At the bottom, after the signature.
No, I understand. This is what a chartered accountant firms. So they are using this UDIN number.
Yes, madam.
I understand 2579.
And it is the same UDIN number that is referred to in the PL statement that they have filed, as well as it is based on this UDIN number that we verified the records from the Chartered Account website, which says 56 crores. Here, at serial number 3, serial number 1, madam, kindly say it is 36 lakhs. Serial number 2 for 23-25 is 90 lakhs. 24-25 suddenly jumps to 60 crores. whereas the record shows it's 56 crores, my lord. That is why we have come across this lordship. It could not be 60 crores. The statement is incorrect.
Have they disowned that I have not issued the certificate?
Well, that is what they are accused.
Sorry, sir. A chartered accountant, he is using a third party's the document. You are using a third party document. Now, this third party must ensure that I have not issued, or this is not my signature, I have not done it. Now, I understand, but these two persons, I do not know of the chartered accountant when you talk about all these kind of things where he has said that the audit report shows that the total turnover is 56 crore. But the certificate which the partner accountant, chartered accountant firm has issued, that shows that the turnover is near about 60 crores.
Yes, madam.
Now, this discrepancy you wanted, I do not know what is the authenticity of this document at page 306 and genuinity of the document at 283.
May. What happens nowadays, anyone who files a return has to file along with the UBI number, unique document identification number. Every chartered accountant who files a return or any document for anything has to give a UBI number.
True. Even now you have to give registration number. Yes, everybody. Yes.
Basis that UBI number, they have used this UBI number to file their returns.
I am asking you, sir, it appears that it is issued by a chartered accountant firm on his letterhead.
Yes.
There is an audit report. There is a signature. I just wanted to know genuinity when you are raising an issue, whether this is a spurious one, this is a manufactured document, whether these partners have ever come forward and say that, yes, I never did it.
May I come?
How do I know?
May I take a look at page 285? To bring it to not say why they are relying upon these two documents and the document filed before the ICA and the website to say both of them different. If it's declared before the ICA and the website of 56, these two documents cannot be correct. That's why I made.
Now, if these two documents are stated as correct, then this ICAI document may not be correct. There may be some typographical error. Will not be. Who will certify? These persons will certify.
Because therefore the FAQ says.
Sorry, we can't.
The FAQ requires that every document that is submitted, the UDN number has to be there. The UDN number here, all these three documents have one UDN number, and there are three different figures, two different figures.
I understand, sir. Then some explanation is required. Then there may be a possibility, as a neutral man, that this figure may be actual figure, the other figures are wrong.
That is why we have come up with the lordship.
3 may be an actual figure, but the other figures may be wrong. No, sir. Then it is a notice. Who is appearing for the other side?
My lord, a copy has been served upon me, my lord. I appear for Odisha State Road Transport, my lord.
My lord, can you see the FAQ?
No, where is this party?
Notice has to go.
That is what I wanted. This party must be noticed.
3, 4.
Huh? 3, 4 or 3?
3 and 4.
3 and 4, five.
Why 4?
4 is one. There are constitutional members. 3 is the lead member and he is an associate member.
Is a consortium which is coming.
The lead member, it is the requirement of bid tender that the lead member must have
notice.
60 crores of financial income for 3 cumulative period of 3 years.
Already.
I'll take notice for OP1, my lord.
Yes.
May I actually technify we have special mission. We have special mission to go by the special mission. May I play not?
What? No, go by post, huh? Speed post. By speed post.
Yes.
That is a short resettlement that may not serve because they
You find the requisites tomorrow, it will go by speed post.
Just to go outside the state.
You find requisites tomorrow.
Yes, I will.
As far as one is concerned, my lord, I appear.
Yes.
Item 28.
2 weeks.
29th.
Notice an IO.
I noticed now.
Item 28.
Not sir, if it can follow. If it can,
weeks I have already said.
29 cases.
if it can be taken up in the first admission, I may only claim, may only claim errors.
You take instruction books. Mr. Anand Prakash was there.
Item 28.
And item 17, the criteria fixed in the tender, that is 3.1.5.
2.1.5 is it what page, madam?
I know that particular page has
Page
been
31.
31,
Page 30.
page 5.
Just 1 minute. Let us first read 2.1.5. Yes.
My lord, because of this condition, I will be debarred from participating because although I have conducted similar type of work before
The similar work has been defined.
No.
In this tender,
what?
in other tenders, you define the similar work. I'm just asking.
That apart, my lord, it is also reached by the judgment of the Honorable Supreme Court, wherein it has already been said that if the criteria have no rational nexus with the object to be achieved, then that is illegal. And I am having the judgments, the Lordship kindly.
My judgments, our judgments, not my judgments. That's why I'm smiling after hearing all these things.
Sorry, my lord.
Please. Similar work, similar nature has been defined, same tender, same concept.
I have not.
Give him a copy, give her a copy. No, this is our judgment copy. Please, we are bound by it, madam.
This judgment is taken note of.
I know, that's why I'm saying Vinisha's judgment has been taken note of.
Yes.
Also, let's talk about another judgment.
But
Another case.
here, but and so far as this case is concerned, my lord, except stating that the similar nature of what I must have done within the last 3 years, financial years, nothing is there. I have, my lord, similar type of work I have done. But for this, my lord, criteria, I'm not.
That is why I heard that it is within the exclusive domain of the tendering authority.
My lord, may I?
They can, because of the nature of the work that is to be done. This is another where this Vinishma, this judgment has also been considered. And
that depends on if it is involved some skill or technological.
This is what I have said. The judgment which is paragraph 3.2 of this judgment. We have referred that Supreme Court judgment which you are relying. Same word which you uttered has been used.
Yes. But so far as this tender is concerned, there is nothing enumerated that what is the similar nature of work. It has not been defined. Your Lordship will kindly.
What is the nature of the work?
My Lord, bridge and road work. That is the work. And I am a contractor, ATS contractor. I have also done similar type of work. And I have also mentioned, my Lord, your Lordship may kindly talk.
Why don't you go through the judgment and then come unnecessarily?
Yes.
Because
Your Lordship may.
we know what we have held, so that will be a problem.
Yes.
You go through it.
Yes, I will go through it. Your Lordship may keep it to Monday.
Monday.
Oh, bless.
Item number 29.
Last week, I have given the written notice of submissions.
With bonds of judgment, my last branch I have to give. I have
gone through it. It will be delivered.
By binding.
Give. Do you have anything to add? Maintainability of the public interest litigation.
Here, I'll just refer to his own representation which he has given to the authority. In fact, by way of this EIA, they want to unsettle the settlement or entry in the record of rights, which are already made long back by operation of law.
File your written notes of submission.
I'll submit by end of this week.
Yes. The counsel for the petitioner hands over the compilation of the judgments. Other way, your submissions, and I was just going through those judgments as well.
By the elapse of changing of counsel, my lord, the stand of the government cannot be.
No, that's true.
Because once you admit in
No, that is a different issue. We are more concerned with the public interest litigation. Then
it's a great decision to me, but we go homework to
let us see.
Item 30.
Then my last question was the call for instruction government law. Here, in this case,
encroachment, the same thing.
Just I received instruction, my lord, in this place, my lord, certain the piece of property has been requisitioned by the government. But so far as the other area is concerned, my lord, we
requisition or acquired by the government. I'm just wanted to know.
My lord, it will be, my lord, for government public purpose, my lord. That particular area is to be used for a creation of a statue or some other public purpose. We are de-reserving that particular plot of land now. The process is going on. A certain area of that plot, but regarding the other areas, we need to undertake a demarcation, for which they have asked for 15 days time to demarcate and initiate encroachment cases if any encroachment is found. 15 days, if my lords will allow me.
You'll have to file your affidavit.
Yes, my lord. I'll file it.
You disclose it. It's not so easy because you are saying here that you are contemplating to deserve certain areas.
Well, that is the instruction, but
and there is a different concept. Concept of requisition is different and concept of acquisition is different.
Not acquisition, here it is not acquisition.
Requisition, there must be an act by virtue of which you can require or requisition the property.
Yes.
The ownership remains with the owner. Only thing is that the user. Yes. And you'll have to pay the rent for that, yes, to the original owner.
This is Gochar land, so primarily belongs to the government. So the government wants it for some public purpose. So I file my affidavit on that. Also, will undertake a demarcation.
But it is submitted by the Next.
Item 31.
31 because we have filed a counter affidavit, my lord.
Counter in a PIL.
My lord, affidavit. My lord, 9th, my lord, just served the copy on 10th. My lord, hard copies, my lord, they have not come on record, my lord, I'm submitting.
Construction of the road, my lord. Not legal. So I have received it on 10. If your lordship grants me each time, I come up with a.
Yes. Peruse, let the counter affidavit for filed today be taken on record.
Well, the petitioners are the poor villagers.
What?
The petitioners are the poor villagers.
Poor villagers. Engaged you.
Just could not file the postal liquidation.
Yes.
For opposite parties.
362 opposite parties, my lord.
Could not file the liquidation and take number of opposite parties.
Then we'll have to.
In that case, my lord, under Annex 10, a representation is pending before the council. That will also. The councillor Margaret is
No.
under Annex 10.
No. He directed the service to be effective. He could not. He was already there. Huh? No, no. Earlier. What are they?
Wanted demarcation of measurements of that land. গৃহীত প্রার্থনা করেছে পুনর্বার ସମସ୍ତଙ୍କୁ ନୋଟିସ ଲଗେଇବା ସହିତ ହାଇସ୍କୁଲ ଜାଗାକୁ ଆପଣଙ୍କ ତରଫରୁ ସଠିକ ଭାବେ ମ୍ୟାପ୍ କରିବା ହାଇସ୍କୁଲ is yours.
Yes,
it is government high school.
Yes.
They require that area to be demarcated.
Yes, ma'am. I will take instruction. Let's follow this matter next week. I will take instruction. And for that demarcation, they have to submit an application in the prescribed format. Whether they have done it or not.
You are villagers.
Yes.
You see that earlier certain cases were difficult of it. And you are not taking care of it. You are given notices to certain persons. But you are not given to all. That is there.
We've taken up next week. In the meantime, I've taken. Unless you give a translated copy, I am unable to respond. I am just a good listener because I can't read what you have written in your representation. I do not know anything. I am just relying
On the next
take instruction.
That's some information. We are just adjourning.
Why don't you file a translated copy, sir? How can you expect that everybody should know? Yes. Next.
Item 33.
33, 34, next to. Next to.
Next.
Item 35.
Next to.
Item 35, sir.
I was not appearing to the petitioner. I was on the last date and directed the state to seek instructions.
Yes, what is?
Let us some time be granted for filing of a counter. Counter is required because another writ application is also pending. So,
what counter is required? What is the issue here?
It's with escalation cost.
Escalation bill.
Escalation bill. So
we'll have to just seek an instruction that what is this?
Not do because another writ application also may take up this matter.
Whether the clause permits, whether they are coming within the purview of that clause, escalation clause, everything you'll have to be. We just wanted that what are you doing and processing the application or not?
No. Already division bench.
My instruction is not.
Two decisions of division bench is the prayer he has made. Raghunath Sahu and Sujaman.
No, he is not entitled by issue. He is not entitled to get it.
See, tell him, communicate, and the reason is that why he is not entitled.
I'll file a counter.
Counter.
Counter is required because another case is also there involving the same issue.
It really invites the pendency. Counter by 1 week, better to appear in the next week.
Item 36.
What is the instruction?
Please to direct the responsible to
In this matter, we were filing affidavit by tomorrow. Let it be taken up next week. Some actual aspects are there. We're filing that affidavit by tomorrow.
Please to direct to specific instruction asking whether my application for extension of time was acted upon or not.
What you have done for extension of the execution, the application is pending. What decision has been taken by you? We just adjourn it for that purposes.
Yes, ma'am. I have said.
So,
Order dated 1/9/2025.
absolutely. We have simply said on that.
Yes. Para 5 years to.
Yeah, he has to answer.
This is the last page that I have marked. The last page, starting from the paragraph further.
That's it. Instruction document.
You have not stated anything because the second, he said first stage I have completed, second stage that falls within the pandemic area, the period, and then he asked for an extension using the force majeure clause. You have to take any conscious decision on this is taken, nothing. Simply last paragraph.
As he did not submit that proposal within that time period, as per clause 4 of the.
So when the pandemic struck, this is struck in the month of March
2020.
And the extension was April. How could they complete it?
During pandemic period, this construction, what other works were not stopped.
Sir,
we have not received a mass exodus of the laborers. If they do not get the workmen, then how they will do it?
you are not there in India or is this?
He was not there. He was actually confined in the house.
That's why I'm submitting letter to file an affidavit.
What affidavit? What kind of attitude is of the officer?
Because where it was not entertained, they have accused the head.
Sir, there was a complete lockdown in the first phase. And this started in the month of March. And there was a complete lockdown. There was no work. Not even establishment was there except the essential services. Nobody was permitted to move out of the house.
In April 2020.
Yes, that was in March, from March to April. Yes. Whole of the April.
Then shutdown, containment zones, then restrictions. Honorable Supreme Court in 2022 extended.
That I am not putting it, but they have written it.
Sir,
I cannot go beyond that.
Cannot be. Give them an affidavit. We'll take care of that. Let them come with the stand. Let us see what they say. Counter by 1 week. Let them come. Affidavit by 1 week.
Revenue and disaster management circulars and letters. Will we have that?
Your item 67 was kindly consider the stay with the big project 180 will be construction. Because of the stay order, because it is facing difficulty.
67, can we fix this matter on Monday? Because we are fixing some matters on Monday.